I still have my citation from last time. I'm still going.
I don't care about citation from last time. Get out of the vehicle. You're under arrest. Plus the fucking window. I don't give a shit.
In today's video, we'll be looking at 3 sovereign citizens. The first is a familiar face, a so-called sovereign citizen Karen I've covered before. She decided to argue with police officers about her supposed right to travel while standing on the side of the road. Unsurprisingly, that didn't end well for her, and she ended up paying the price, with her infamous lickable window.
Okay, we had just called 25 CR 250, State of Kansas versus Sidney Taylor Leslie. Jared Regier for the state. Miss Leslie appears in person and per se. Miss Leslie, is that you?
Yes, Your Honor.
Where's your attorney? Are you going to have an attorney represent you?
I am presenting myself.
You know you have the right to an attorney, to hire any attorney of your choice. If you cannot afford to hire an attorney, you can apply, which I think you've already done, but you did not request an attorney, is that right?
I did not request an attorney. That is correct.
You want to proceed on your own behalf, and you can do that. No one's going to stop you from doing that. But is anyone making you give up your right to an attorney today by any threats or promises?
No.
And you understand you can hire, and if you can't afford, you can apply for court appointed, and if you qualify, one would be appointed. Do you understand that?
I comprehend, yes.
You do not wish to have an attorney?
I do not wish to have an attorney.
All right. I will show on the record that you've waived your right to an attorney and that you're going to proceed on your own behalf. So how do you plead then, Miss Taylor, or Miss Leslie, I guess it is. I'm sorry, I'm just saying it wrong. Miss Leslie, how do you plead to count 1 interference with law enforcement officer?
A plead would be inappropriate at this time. I'm hoping to request a continuance.
Why would a plea be inappropriate at this time?
Okay, so, Your Honor, for the record, I am Sidney Taylor Leslie, in propria persona sui juris. I am here by special appearance only and not making a general appearance. I reserve all of my rights, remedies, and objections, including, but not limited to, any objection to jurisdiction over my person. I require a continuance in this matter. I intend on filing a subpoena for body cam and cruiser footage. There are facts in dispute on this matter that I'm looking to clear up before the matter can continue further.
Before we dive in, I want to take a moment to thank today's sponsor, Ground News. Ground News is both an app and a website that compiles news stories from across the globe and presents them all in one place. For example, in their coverage of Trump extending the China tariff truce by 90 days, you can see not only the story itself but also a political breakdown of how it's being reported, along with a factuality rating for each outlet. In this case, 88% of the sources had a high factuality rating, and 53% were politically central. One of my favorite features is the blind spot tool, which highlights stories that are heavily covered on one side of the political spectrum while being ignored on the other. For instance, a report about James Clapper pushing to expedite a 2017 intelligence assessment received 95% of its coverage from right-leaning outlets and none from the left. Conversely, the story of Germany and its allies sending a major military aid package to Ukraine through NATO supply lines was reported by 90% of left and center outlets, but only 10% of right-leaning ones. Ground News gives you a broader perspective and helps you spot these gaps in coverage. If you'd like to try it for yourself, click the link in the description or scan the QR code on the screen for 40% off. Thanks again to Ground News for sponsoring this video. Now, let's get started.
All right, I will grant a continuance for you to obtain discovery, but if you don't know how to do the things you just rattled off, you better have an attorney do it for you. Do you understand?
I understand.
All right. Mr. Aguirre, do you wish to be heard before I pick the date for this?
Your Honor, this does appear to be the first setting since the first appearance hearing before Judge Hart back in June. If the court is prepared to set this matter over for discovery purposes, the state does not object. I'm not sure if the court wishes to set that matter for merely control at this time, but I'll defer to the court on that point if the court will find that the bond is being continued and this continuance is at the request of the defense for speedy trial purposes.
All right, Miss Leslie, you're charged again with interference with law enforcement officers, a Class A non-person misdemeanor, driving without insurance, a Class B misdemeanor, and driving without a license in your possession, an unclassified misdemeanor, as well as failing to register your vehicle, another unclassified misdemeanor. The judge would have gone over these with you at first appearance. You want to go over them again as far as the penalties?
No, thank you.
All right. And you've indicated you want to exercise certain rights that you are entitled to and encouraged to. But as I said, an attorney could certainly help you carry out those rights. And you said you do not want that attorney?
That is correct.
Okay. Well, I'll have the record and the docket notes show that you have waived your right to counsel and that you know what you're doing. Now, then, do you want to set it for trial, Miss Leslie, or do you want to get the records and look at them and then set it for trial?
I would like to have a continuance, perhaps for discovery or an evidentiary hearing if possible.
Well, I can continue it for both those readings.
Okay.
For both those readings, to give you time to get all your discovery, the dash cam, body cam things you were mentioning.
Okay.
And then we can also set it for trial. So when's a good trial, 1:30 trial date, Jim?
Your next one will be September 24th.
All right, you'll need to be back here with all your witnesses September 24th, 2025 at 1:30, and that will be by Zoom again.
Your Honor, if I may just get a little more time due to the fact that I'm going to be submitting the subpoena and I'll need discovery and I need to just review it so that I can have adequate time to present myself for my defense.
Well, that's 30 days. You don't think that'll be enough? How much time are you asking for?
I'm hoping for at least 60 days.
Jen, do we have 60 days?
We have October 22nd or October 29th at 1:30.
Which of those do you prefer?
I would prefer October 29th.
October 29th. This is continued to October 29th at the defendant's request. Is that over your objection or not, Mr. Ricky? I don't remember any objections.
Your Honor, if the court is prepared to set this matter for trial, the state does not oppose that, but the state will be requesting a ruling as to whether or not the bond is to be continued and if this continuance is at the request of the defense.
Court does find this request at the defendant's, and the time will count against the defendant for speedy trial purposes. The matter is continued for bench trial to be heard and to be commenced August 22nd, 2029 at 1:30 p.m. via Zoom. So, Miss Leslie, it's going to be here by Zoom. Right? Be sure you have your evidence ready. If you're going to screen share it, whatever you're going to do, make sure you can do that. And if you need any help getting your discovery or presenting your evidence, you're always able to hire an attorney. And if you can't afford one, apply, but do it well in advance of the trial so that you can get the application completed, returned, and the court can appoint your attorney, and you and the attorney can have time to present your case.
Okay, yes. Your Honor, I did hear you say October 22nd. Was it the 29th that I had requested at 1:30?
You did, so I'll make it October 29th. Jen, you said
Thank
either.
you.
You said either, and she picked the 29th, correct?
That is correct, Your Honor.
It'll be October 29th at 1:30. Now, Mr. Regier will be subpoenaing witnesses himself for the state. And if you find out or decide you don't want to go with a bench trial, let him know as soon as you can so he can cancel any of those witnesses that he may have coming in.
Thank you, Your Honor.
You're welcome. And don't forget, you can look at diversion and see if that's an option. You can call the county attorney But definitely look into that issue of an attorney.
Okay, thank you, Your Honor.
You're welcome. Anything further from the state, Mr. Regier?
Your Honor, if the court is continuing the bond in this matter, I have nothing further at this time.
I am continuing the bond. All existing conditions plus the new ones I've stated on the record today.
Thank you, Your
And
Honor.
you're welcome. And Miss Leslie is excused at this time.
Thank you,
You
Your
can
Honor.
request the body cam footage as much as you'd like, but the reality is that you posted the video online yourself, and the facts speak for themselves. You refused to follow lawful commands, and as a direct result, you ended up, quite satisfyingly, eating glass.
And we have defendant Jose Elizondo.
Yes.
Mr. Elizondo, you have a motion that was filed, so we will get to that after I take everyone's announcements. I just want to let you know that I do have you here, and I see that you're here, but I'm gonna take the announcements first, then we'll get that heard. All right, so if you can just stay logged in, we'll get you processed through promptly, all right?
All right.
Okay, thank you. All right, Mr. Bishop, we have two defendants with motions, and then we have one defendant set for trial. All right. So the first case set for motion is Jose Elizondo. Mr. Elizondo, if you can please unmute and share your video.
I'm here.
Okay, thank you. So, Mr. Elizondo, you had a pretrial hearing earlier this year in May, and then and at that hearing, you had indicated that you had mailed in a motion for a bond, and that was the only motion that you had, and we did not have that here. After the court, and we set your case for a jury trial on August 28th. Then after the date of your pretrial hearing, we received a motion in the mail stating defendant's Rule 91 motion to dismiss for failure to state a claim upon which relief can be granted. Mr. Bishop, have you received a copy of that motion?
Your Honor, and made a response.
Thank you.
I believe he's filed two motions. I've got a motion to dismiss and then a motion, no consent given motion.
It looks like this young Karen has a court date scheduled soon, though we may not get to see it since in-person appearances in Kansas typically aren't live streamed on YouTube. I'll be keeping an eye on the case offline, and if there's any resolution, I'll be sure to bring you an update in a future video. For now, let's shift over to my home state of Texas, where we have a follow-up on another case I've been covering, this one involving a sovereign citizen by the name of Jose Elizondo.
Yes, that's correct. All right. So, Mr. Elizondo, if you wish to summarize your argument, you may do so at this time.
Yeah, I just want to know, do y'all enforce the Texas Transportation Code?
No, sir, we're not answering questions. You need to summarize your motion at this time.
All right, well, I just want to add to my motion that according to the Texas Transportation Code, Title I, Section 502.003 clearly states it prohibits political subdivisions from requiring registration, and my violation was due to registration. So that's all I wanted to add, and I plead not guilty and for dismissal too.
Mr. Bishop, your response?
Yes, I addressed this in my response, Your Honor. The city of Dalworthington Gardens is the political subdivision of the state of Texas. And this registration requirement is not a violation of a city ordinance. There is no city ordinance that requires individuals to register their vehicles. That's state law. And so the defendant is incorrect in applying that statute because it's a state law violation, not a city ordinance violation.
The court has read the defendant's motion to dismiss, and I have read the state's response to that. And the court is denying the defendant's motion to dismiss. I don't see where you prepared an order for me to sign. Let me see.
I did not prepare one, Your Honor, but I will be glad to prepare one.
Okay, if you can prepare one, Mr. Bishop, I will get that signed. I'm writing a notation here. Motion denied. Right. And then we have the second motion, defendants, no consent given. Mr. Elizondo, you may summarize your argument at this time.
Whatever I submitted is what I plead to continue with.
Mr. Bishop, would you summarize the state's response?
Yes, the state's response is in the state of Texas, driving is a privilege, not a right. And by exercising his privilege to drive on a Texas highway or street, he is subject to all rules of the road, statutes, and rules. And so the state does not need his consent for him to be subjected to jurisdiction when he has violated a state law. He's not being denied his rights. Driving is a privilege, and by driving, he subjects himself to the rules of the road and other state laws regarding
Come to
driving.
think of it, I can't remember a single case I've covered where a defendant willingly consented to be prosecuted. Jose, meanwhile, apparently has a bowl of edible paint chips I'd love to ruin, so let me be the one to break his heart. Your consent isn't necessary.
All right. Based upon the court has reviewed the written motion and response, motion by the defense, response by the state, has considered the arguments made here in court, and the court is denying the defense statement of no consent given to jurisdiction. Okay, so Mr. Elizondo, your case is set for jury trial on Thursday, August 28th at 8:30 in the morning. That is when you need to be here. You have cited in some of your motions civil rules of procedure. As I have warned you before, I'm warning you again, the Texas rules of criminal procedure apply in this case. This is a criminal charge, and you need to follow the Texas rules of criminal procedure. You will be expected to follow proper courtroom decorum, and as you are representing yourself, you will be held to the same standard as if you were an attorney. You will need to be here at 8:30 in the morning. You will receive information regarding the venirement, the potential jurors, and voir dire will start at 9 a.m. You will be given 15 minutes to ask relevant questions of the venire panel. The state will be given 15 minutes to ask questions of the venire panel. Each side is given the opportunity to make up to 3 strikes, and then we will proceed to the jury trial that day. Have any witnesses that you wish to call and any evidence that you wish to present here and ready when you get here at 8:30 in the morning. Do you understand, sir?
Yeah.
Okay. All right. Mr. Elizondo, is there anything else that you wish to put on the record at this time?
No.
Mr. Bishop, anything from the state?
Nothing further from the state, Your Honor.
Okay, Mr. Elizondo, you are released at this time. We'll see you here in person at 8:30 in the morning on August 28th.
Sounds good.
You are released at this time.
Like I said, your consent isn't required. By taking your Pinto out into public and putting those 4 circular objects we call tires on the roadway, you automatically consented
James,
to
are you
the
there?
juris.
Please unmute.
Yes,
Okay. Mr. Haynes, are you able to share your video?
I'm working. I'm trying to.
Okay. I know all the controls are a little different. While you're doing that, I'm just going to go through the preliminaries. There we go, sir. So I show you that you have 2 cases pending. We have a expired registration and failure to maintain financial responsibility. And you sent in a motion to dismiss. And you also came in, that motion to dismiss came in on the 5th, and then you came in today and put down a cash bond of $21 towards the expired registration charge. So So, sir, I want to ask you, did you hear my explanation about defendant's rights and options that I went over at the start of court?
Yeah, I grant the court's permission to use my name.
Okay, sir, I asked you a question. Did you hear, sir, did you hear the rights and options that I went over at the start of court?
I'm granting the court's permission to use my name for future return on my equity. And you're asking me if I heard what?
I'm asking you, did you hear my explanation about defendant's rights and options that I went over at the start of court?
I heard, yes.
Do you have any questions about those rights or options?
Not about those, no.
Well, what question do you have, sir?
I sent in and it was registered that you received an abatement. And my question basically before I submit any plea of any type is the jurisdiction, the subject matter jurisdiction. And in my motion to dismiss, it kind of covers all of that.
All right. Well, sir, this is a statutorily created municipal court, and I do have jurisdiction over Class C offenses alleged to have occurred within the jurisdiction of the city, the extraterritorial jurisdiction, and within Tarrant County. And you do have a motion to dismiss. We can have that heard tonight with Mr. Bishop with his response, and then we'll proceed from there.
All right, that wraps up the hearing. I'm not entirely sure how accessible this trial will be since I don't know if Tarrant County puts in-person trials online, but luckily, I happen to live in the area. I'll see what I can do about getting a camera into the courtroom, strictly for journalistic purposes, of course. Now, let's move on to the final hearing of the day, which conveniently took place in the very same courtroom immediately after Jose.
Mr. Bishop, we have the defendant Vincent Luis Haynes. He's facing 2 charges, expired registration and failure to maintain financial responsibility. And in July, he filed a notice of abatement. And a motion to dismiss. Mr. Haynes, can you please, there you are, Mr. Haynes, there, unmuted. All right. So, Mr. Haynes, do you wish to summarize your motions at this time?
Yes.
Go ahead, sir.
In my notice of abatement, I'm asking for the court to show that it can uphold the Constitution in reference to Article 6. I'm basically stating that I am a natural person. You know, I'm in the court even currently right now with my Lord and Savior Jesus Christ, and the notice of abatement just goes to the heart of the matter as to the jurisdiction. Both subject matter and personal jurisdiction, and to make sure that these proceedings are done to assure equity and fairness. I realize that this court may not provide a remedy for me, and so at that point, I'm asking for adjunctive relief if that would be appropriate.
Mr. Haynes, you're using terms that are civil terms. This is a criminal court. These are Class C criminal charges, which carry a fine as their punishment. This is not a court that gives a remedy to a defendant. You are charged with a citation. You are charged with a crime based on the actions of a police officer.
Who did I offend?
No, sir, hang on. I'm not done.
Okay.
So I want to make sure you understand you're using civil terms. The rules that apply in this court are the Texas rules of criminal procedure. And those are the rules that dictate how the hearings and trials will proceed. And it is the Texas laws which grant this court jurisdiction in these matters. I'll make sure you understand that. If you wish to continue to summarize anything, you may. But I want to make sure you understand you're using civil terms. This is a criminal court.
Okay. Even in a criminal matter, ma'am, I still have a right to face my accuser. Again, with that's what the abatement was about, and who accuses.
Sir, hang on a second. You haven't gotten to that point yet because this is a first setting, and if you plead not guilty, there will be a trial. But as you've seen here tonight, many people plead no contest or are guilty. Therefore, there is an opportunity to hear and have all the accusations presented in court. You just have not gotten there yet.
Yeah, I don't.